Hello friends, myself Divyanshu Sharma and I'm second year student of MD Law University, Gwalior, Madhya Pradesh. And my topic is in present I am working as a legal intern with LEXIS and Company. And my today's topic is Doctrine of Eclipse. The Doctrine of Eclipse says that any in law inconsistent with fundamental right is not valid. It is not that totally but invalid, overshadowed by the fundamental right. The inconsistency can be removed by constitutional amendment to the relevant fundamental rights, so that ellipse vanishes and the entire law becomes valid. In other words, till the time a law violates a fundamental right provided by the Indian Constitution, it is dormant and inoperative. But if such fundamental right is amended and thereby the law no more violates, then in such a situation the law becomes alive and operative, and such ellipse law exists for all post transactions of the right post transaction and for the enforcement of rights acquired and liabilities incurred before the commencement of the constitution. It is only against the citizen that they remain in dominant or moribund condition, but they remain in operation as against non-citizens who are not entitled to fundamental rights. Landmark judgment, we can say, in Bikaji versus State of MP, AIR 1955 Supreme Court, SC 781 case. The provision of CP and Berar Motor Vehicles Act 1948 authorized the state government to take up the entire motor transport business in the province or to the exclusion of the motor transport operator. This provision, though valid when enacted, but became void on the commencement of the Constitution in 1950, as the violated Article 19(1)(g) of the Constitution. However, in 1951, Clause 6 of the Article 19 was amended by the Constitution so as to authorize the government to monopolize any business. The Supreme Court held that the effect of the amendment was to remove the shadow and to make impugned act free from blemish or infirmity. It became enforceable against citizen as well as non-citizen after the constitutional impediment was removed. This law was ellipsed for the time being by the fundamental right. As soon as the ellipse is removed, the law begins to operate from the date of such removal. Effect of ellipsing is only against the citizen that they remain in the dormant or moribund condition, but they remain in operation as against non-citizens who are not entitled to the fundamental right. And another case, we can say that in Keshwa Madhava Menon versus State of Bombay case, the petitioner was prosecuted under a press law for publishing a pamphlet without permission while the prosecution was on constitution commenced, and he challenged the act as unconstitutional. Issue arose: A, whether section 50 in subsection 1 and 18 subsection 1 read with the definitions contained in section 2 subsection 6 and section 2 subsection 10 of the Indian Press Act 1931 were inconsistent with Article 19(1)(a) read with the subsection 2 clause 2 of the article, and B, assuming that they were inconsistent, whether the proceeding commenced under the section 18 subsection 1 subclause 1 of that act before the commencement of the constitution could nevertheless be proceeded with. These are the questions. The court held that constitutional right came from the date of commencement of the constitution. The question of inconsistency of the law, existing laws with those rights were necessarily arise on and available, and right must necessarily arise and form the date those rights can be into being. This the law become void or not into or for all purposes or for all times or the person they, but only to the extent of such inconsistency. This is to say, to the extent it become inconsistent with the provision of Part 3, which conferred the fundamental rights of the citizen. Thank you, friend, and have a nice day. I hope that you liked my video, and if you have any problem related to the topic, please let me know in the comment section. I will figure out your problem, and please subscribe the channel and press the bell icon. Thank you and have a nice day.